Good evening, everybody. Today, I am going to discuss on the topic that whether bail is a right or a discretion. Here, before going to the topic, we have to discuss on the concept of bail. What is concept of bail? Bail is well understood in criminal jurisprudence and chapter 33 of Criminal Procedure Code contains elaborate provisions relating to grant of bail. Bail is granted to a person who has been arrested in a non-bailable offence or has been convicted of an offence after trial. The effect of granting bail is to release the accused from internment, of the court would still retain constructive contract could still be exercised through the conditions of the bond secured from him. The literal meaning of bail is surety. According to Article 21, no person shall be deprived of his life and personal liberty except according to the procedure established by law. According to Article 22, the protection against arrest and detention in certain cases which envisages the rights of the arrestee after he is being arrested. Hence, any procedure dealing with bail is measured in the light of provisions of Article 21 and 22 of the Constitution of India. Therefore, the matter of bail is to be considered in the light of right of accused, but not as the totally discretion point. However, according to clause 4 of Article 22, no law providing for preventive detention shall authorize the detention of a person for a longer period than 3 months unless an advisory board consisting of persons who are or have been or are qualified to be appointed as judge of a high court has reported before the expiration of the said period of 3 months that there is in its opinion sufficient clause for such detention. Provided that nothing in this subclass shall authorize the detention of any person beyond the maximum period prescribed by any law made by Parliament under subclass B of class 7, or such person is detained in accordance with the provisions of any law made by Parliament under subclass A and B of class 7. According to section 436A of Criminal Procedure Code, where a person has during the period of investigation, inquiry or trial under this code of an offence under any law not being an offence for which the punishment of death has been specified has one of the punishments under that law undergone detention for period extending up to 1/2 of the maximum period of imprisonment specified for that offence under that law. He shall be released by the court on his personal bond with or without sureties. Grant of bail is a rule. The Supreme Court of India observed that grant of bail is a rule and refusal to bail is an exception. In state of Rajasthan versus Balchand case, the Supreme Court had observed that the normal rule is bail and not jail. The judicial discretion exercised in granting bail is neither perverse nor erroneous, rather they are based on relevant conditions supported by the reasons. However, the grant, refusal or cancellation of bail is a judicial act and has to be performed with judicial care after giving serious consideration to the interest of all the parties concerned. The matter of bail is not merely procedural right, but a substantive fundamental right. According to the Supreme Court, in the matter of State of Kerala versus Ranif, in deciding bail application, an important factor which should be certainly be taken into consideration by the courts is the delay in concluding the trial. Often, this takes several years. And if the accused is denied bail but is ultimately acquitted, who will restore so many years of his life spent in custody? Is Article 21 of the Constitution, which is the most basic of all the fundamental rights in our Constitution, not violated in such a case? Of course, this is not only the factor, but it is certainly one of the important factors in deciding whether to grant bail. However, Supreme Court has given some guidelines for granting or rejecting bail applications. Those are, first one, whether there is any prima facie or reasonable ground to believe that the accused has committed an offence. And second one, nature and gravity of the charge. And third one, severity of the punishment in the event of conviction. And fourth one, danger of accused absconding or fleeing if released on bail. And fifth one, character, behavior, means, position and standing of the accused. And sixth one, likelihood of the offence being repeated. And seventh one, reasonable apprehension of the witnesses being tampered with. And eighth one, danger, of course, of justice being thwarted by grant of bail. So, at the time of either granting or rejecting the bail, courts must follow the guidelines given by the Honorable Supreme Court of India. However, purpose behind the bail. What is the main principal purpose of the bail means? The main principal purpose of the bail is to ensure that an accused person will return for trial if he is released after arrest. The main purpose behind the grant of bail is that the consequences of long detention of the pre-trial accused persons who are presumed to innocent as any other citizen is very grave. The salutary provision contained in section 438 of Criminal Procedure Code was introduced to enable the court to prevent the deprivation of the personal liberty. And if we are coming to the point that why bail should be granted, the research and study by various agencies has shown that out of 2,000 accused persons released on bail, less than 1% failed to appear before the courts when required. However, if the accused person who is presumed to be an innocent person at pre-trial stage is not granted bail, he would lose his goal if he has won. In that situation, his career will be in jeopardy and all the members of his family will face starvation without any valid reason whatsoever. Burden of detention, therefore, falls heavily on the innocent members of his family. The accused person under detention will also not be able to prepare his defense against the state or the complainant, who are his unequal adversaries. If he is released on bail, he would be in a better position to prove his innocence. Moreover, the public exchequer has to bear the cost of maintaining the accused person in jail. Therefore, the accused persons who have deep roots in the society and are not likely to abscond should invariably be released on bail by the courts. Thank you, all of you.